I want to welcome everybody to this live virtual CLE that's jointly sponsored by the City of Charleston Municipal Court and the Charleston County Bar Association. I'm David Wolf. I'm a volunteer with the Charleston County Bar Association. I wanted to take a moment to welcome everybody to this program and address a few housekeeping matters at the outset. The agenda and materials for the program, I've posted in the chat a link to those. So if you click on that, it should give you access to the PowerPoint presentation that Drew is going to be operating off of and other materials that we've been provided along with the agenda. Now, we've applied for approval for credit through the Commission on CLE for an hour and a half. Normally by the time of the program, we will have an approval code that we can provide to you. However, it's our understanding that the Commission is a little backlogged at this point. Maybe I think we're getting close enough to the end of the year that everybody's rushing to get these programs in. So we do not have that yet. We will do our best to pass out the approval code as soon as we have that. This program is a free service provided to members of the Charleston County Bar Association in good standing. If anybody should have a question or concern regarding their membership status, they can reach out to Kim Steele, the Executive Secretary of the bar, and her email address is secretary@charlestoncounty.org. Anybody who is registered but is not currently a member, we'd encourage you to reach out to her and get that, because otherwise you will not be in the list that's submitted to the Commission on CLE. Okay. In spite of the significant limitations to in-person programming, the Charleston County Bar Association was able to get approval after the Supreme Court kind of eliminated the restrictions on the number of hours that you could have in distance learning like this is. And we were able to coordinate the formatting that's required, which includes a measure or confirmation of participation. And so how we do that with this is probably in one of the transitions, we will post a poll. I need everybody who wants credit for this to click the confirming their participation in that poll so that we can submit your name to the Commission and you can get your CLE credit. So be on the lookout. It's a pop-up that will come. Whoever might be speaking at that time, hopefully we won't interrupt you, but please disregard it and continue with what you have to say. And folks will have probably 3 or 4 minutes to go ahead and click yes on that, and then it will close. You know, I want to thank the City Municipal Court for allowing us to assist with this. There aren't enough superlatives to describe Drew Carroll and his knowledge of all things DUI. So I know that this presentation and the rare opportunity to get a view into the City of Charleston's municipal process, both in general and more specifically this new DUI court, is going to be very informative, and I'm looking forward to it. So in order to get things started, I'm going to go ahead and turn it over to the Honorable Lindsay Byrd.
You and Judge Ferguson for organizing the Lunch and Learn today, and for everybody who has signed in to participate. Thanks for your interest and for being with us. I just wanted to help facilitate the introductions from some of our key members of the City of Charleston Municipal Court. For those of you who are familiar with our court, I'm sure you already know many of these people, and hopefully you'll learn a little bit more about them today. First, I'd like to introduce our court director, Miss Lakecia Cofield. And Lakecia, if you'd like to say anything.
Other than being the court director, thank you for the introduction, Judge Byrd. and also to just give you a little insight as to what I've been doing. A personal interest of mine since the quarantine is I have a better appreciation for my health and also the positive relationships in my life right now. I've been with the municipal court here almost 2 years now, and that's all I have to say. Thank you.
Lakeisha has been a great asset. We're lucky to have her. And if you ever have any questions, she's always more than happy to help out and assist with any issues you might have. Next, I'm going to introduce our City Public Defender, Jason Michael.
Hello, everyone. I'm Jason Michael. I am the City of Charleston Public Defender. Thank you, Judge Byrd. Basically, what I do at the court is I am helping those folks who are indigent, get representation through court appointment, and it covers the DUIs or any other offense that the city court handles, the 0 to 30-day misdemeanor charges. So it keeps me busy, but the DUI court is definitely a much needed thing to just focus on how we treat those cases because of how detailed they are and what goes on with those charges. In addition, if I would tell you something about me that I've done since the quarantine is I am running in Hampton Park more than ever. I haven't been able to get, to the gym. I used to work out at a Orange Theory and I miss it, but for now, outdoor exercise.
Next, we're going to have introductions from the members of the prosecutor's office, starting with the city's chief prosecutor, Will Bryant.
Thank you, Judge Byrd. I appreciate the opportunity to be here. I am Will Bryant, the chief prosecutor for the city of Charleston. I've been in this job about 5 years. Prior to that, I was with the police department as their attorney. That's now occupied by Steve Rumlin. And during the pandemic, I have learned how to sanitize just about every surface that I come into contact with and those I'm about to come into contact with. And, I'm going through a lot of hand sanitizer. So some company somewhere is really glad that I'm using their product.
All right, thanks, Will. Next, we have the city's new deputy prosecutor, Shannon Elliott.
Thank you, Judge Byrd. As Judge Byrd said, I am the new deputy prosecutor for the city of Charleston. But if any of you have practiced criminal law for very long, I was at the solicitor's office for 10 years. So my guess is we probably ran into each other there. Excited to be with the city of Charleston. When I'm not with the city of Charleston, I'm kind of a homebody. So the COVID restrictions haven't really cramped my movie watching and book reading ability. So I might be one of those people that was kind of born for a time like this, but excited to start working with everyone here at the city.
We're happy to have you. You're doing a great job, Shannon.
Thank you.
City also has two part-time contract prosecutors. I'm sure many of you know. One of those is Greg Voigt.
Greg did text me. He was having a hard time hearing, so he may not be available.
There's Mr. Voigt.
I'm having computer issues all the way around. I can hear now, and hopefully you can hear me. I'm a contract attorney here at the city. I've been for a couple years. Some of you may know me from various other things I've done. Yeah, I haven't heard enough to know how deep and into it I need to get, but that's about it for me.
Thanks, Greg. And the city's other contract prosecutor is Kevin Hales, and I believe he will also specifically be handling the DUI docket. Kevin?
Sure. My name is Kevin Hales. I've been an attorney for about 15 years. Basically been doing some form of criminal law during that 15 years. 2 stints at 2 different solicitor's offices. I've got a private practice here in Charleston, and I've been a contract prosecutor with the city for about 3 or 4 years. As Judge Byrd stated, I will be handling the majority of the DUI docket. If you do have any DUIs, I have a real fancy email address that you can contact me at. It's charlestonprosecutor@gmail.com. And just to give a little bit of information as to how I go about making an offer on a DUI, I really do try to consider everything, whether or not there was an accident involved, whether or not a breath test was given. If there was one given, what was the reading on that? Whether or not someone did field sobriety tests, how they did on the field sobriety tests. And then also any other indicators that may be on video, be it verbal or nonverbal. I take all of that in consideration when I make my offer. And one thing that does come up quite often is the issue of administrative hearings and whether or not I get involved in those. I will tell you, I generally do not get involved in administrative hearings. The main reason being is that I will not attend the administrative hearings. And so the officers are going to be the ones that handle those. And I'm sure Mr. Carroll is going to talk some about the administrative hearings. Having said that, I do take into consideration if someone receives an administrative suspension. So while I don't get involved on the front end, if you come to me and tell me, hey, listen, we lost the administrative hearing or we waived the administrative hearing, my client's going to be serving a 6-month license suspension and he's going to have to enroll in ADSAP, I will certainly consider that in making my offer. Additionally, if you do contact me and I don't get back to you right away, I would just ask that you understand that I am part-time. I usually try to go into the municipal court office about a week or so before to start preparing for the next week. So I try to address those emails and calls at that time. If I were to call you before then, I don't know how much of an informed conversation we would be able to have, as I probably don't have the files and probably have not reviewed the videos at that point in time. In an effort to speed up that process, and I think most of the defense attorneys in the bar here in Charleston have dealt with me will tell you, I'm pretty fair when it comes to stuff like this. If you know there's an issue with the case, if you say, hey, Kevin, when you watch the video, look about minute 12, you'll see that her feet are cut off on the walk and turn, or the instructions are improperly given on the horizontal gaze nystagmus test, or in the alternative, I had this issue come up this week. If you watch the data master video and you say, hey, Kevin, my client's fingers are all in their mouth the whole time. The officer does not do a good job of checking to see if there are any foreign matter in the mouth. Please take a look at that. Then I will zero in on that. I'll take a look at it. And more often than not, you're right. And you're going to be able to probably get some sort of reduction or maybe even what you're asking for. So I would encourage people to let me know if you see any issues in reviewing the case. You may have 2 on the docket and I may have 100. So you're probably going to be more prepared on the front end on your case than I will be whenever we first make contact. So feel free to email me. The prosecutor's office also has my cell phone number. I think I provided that to Judge Ferguson as well. You can call me on that. You can text me on that. And I will respond to you as soon as I'm able to review your file and have an informed conversation with you.
Thank you, Kevin. That was really informative, and I know everybody appreciated that.
Sure.
This time, I'd like to take an opportunity to have our judges introduce themselves. Our chief judge is Judge Thomas Morrison. He was not able to be with us today. He did send his apologies, and again, also appreciative of everyone's participation and is very excited about our DUI court. Next, we have Judge Maloney.
Thank you, Judge Byrd, and I think this is wonderful. I am, as many of you know, on the call, the judge for the livability court. This is an old-fashioned PowerPoint. I'll be happy to provide that to you, Judge Ferguson, if anybody on the call wants to know more about the livability court. We meet every other Monday, and we also do jury trials. And essentially, we handle any issue that affects the quality of life in the city of Charleston. I'm going to take my mask down because this is what I've been doing extensively for the last couple of months, mask cases. But we deal with animal services, business license issues, tourism, zoning, housing, environmental issues, and of course, loud noise cases with the college kids, as well as parking appeals. And I will say, I've seen the movie you're about ready to see with Dui Cle, but I also knew the star of all of this way back when. Drew, you'll get a kick out of this. Here's my day timer. I tried many cases with the master of the DUI world, Reese Joy. He was a great lawyer, and Drew is following in his footsteps. And I know this is going to be a very informative program today. And it's Friday afternoon, so that's enough from me.
Thank you, Judge. Next, we have Judge Alicia Rico Flores. She is our administrative judge. Judge Rico Flores.
Okay, thanks, Judge Byrd. And thanks, Judge Ferguson, for taking the initiative to organize the CLE. And thanks to all the participants, Drew yes, he's the master. I've been working with Drew for years, and thank you for imparting your knowledge to us today. Okay, the hobby I took up during COVID was gardening. So I started the pandemic with like nothing planted in the backyard. Now I have elephant ears, crepe myrtles, and hollies planted in the backyard. So I think we were asked to give some suggestions also about head attorneys going to or representing in DUI court. I think Mr. Hales pretty much covered everything. I think he gave some great suggestions about how to approach the DUI cases. I would just add, try to make contact before the week rolls around. When Mr. Hales has an opportunity to speak with you, take advantage of that opportunity and try to get the case resolved before the trial week begins. Also, I'm sure everyone's received the email now, or almost everyone, that we are going to have to delay the starting of the jury trials again due to an increase or consistency in the COVID cases. So although we're not going to be having trials, again, use this time to try to negotiate cases and resolve cases. So that's all. Thank you.
Thank you, Judge. And before I have Judge Ferguson introduce himself and move on with the remainder of the program, I want to take an opportunity to introduce myself. Again, I'm Lindsay Bird. If you have any previous experience with the municipal court, you'll know that I was the former deputy prosecutor for the city. Before that, I was a prosecutor for 6 years in Scarlett Wilson's office. And I was just appointed to the municipal court bench in July. Something that I would want all of you to know about the DUI cases specifically is that while we are so lucky to have Kevin and Judge Ferguson addressing a specific DUI docket, you know, those DUI cases start with myself and Judge Morrison and Judge Rico Flores on the traffic court docket. And we are there to assist you in resolving those cases, especially those that you know are probably not or maybe should not be a trial. There's no need to overwhelm Judge Ferguson's docket, overwhelm all the cases that Kevin has to take to trial. And if there's anything that we can do to help you resolve your DUI case off that traffic court docket, we are here to assist you in doing so. Please know that CPD has a policy that dictates their officers are not allowed to plead down a DUI from the original charge without approval from the prosecutor's office. So if you will reach out to Shannon or Will, like Kevin recommended, already point out maybe the weaknesses in the city's case, some issues that you see on the front end, and work out a resolution, and we can have that case resolved in traffic court, and you don't even need to worry about moving it over to the jury trial docket. But again, just know we're here to assist in that as well.
If I can, and I'm sorry, I hate to interrupt you, Judge.
Mm-hmm.
Yeah, and I was just going to say, if you have something that comes up in traffic court and you want to reach out to me, because I know that Kevin is busy with other stuff, please do so. I've been talking with a couple of attorneys who have stuff on there for next week. I think we're going to get resolved and not need to put them on the the jury trial docket. So if you want to do that and you know that there's an issue with be it videotape or something not on the videotape that is going to get kicked under the statute, then just go ahead and reach out to me and maybe we can resolve it that way. Or if there's something that, you know, they might be arrested for DUI, but they don't look that bad, please feel free to contact me, because if we can avoid overloading the already overworked Kevin Hales and Judge Ferguson, then I am happy to help do that.
Absolutely. Thank you, Will. All right, I will turn it over to Judge Ferguson for his introduction and the remainder of the program. Thank you.
Hey, thanks a lot, Judge Bird, and everybody for indulging me in this effort to just open some lines of communication and introduce myself and this new DUI court to everyone. I'll get into more about the DUI court when it's my turn to have a presentation or to present. But I just wanted to let you know a little bit about me. I graduated from the College of Charleston and the Charleston School of Law from Charleston. married and have a son who's 2 and another son who we were expecting in March. So my hobbies take a back seat to taking care of those parenting issues, I guess. But what I do like to do, I guess, something you can do, learn about me is a weird thing I like to do is I like to make up rules about sports, namely what it means to qualify yourself as a fan of any particular sport. I hate bandwagon fans, so you've got to meet certain qualifications. Do you know the name of the head coach? Do you know who the offensive coordinator is? Why do you call yourself a fan? If you can't meet that basic test, then you can't call yourself a fan. So I have these kind of trivial discussions with my friends and family whenever I have time. But speaking of fans, I get to introduce a fellow diehard Gamecock fan, Dui Cle. Not only is he a great resource for knowledge about DUI defense, but he is a good Gamecock fan, and I know he'll be watching Kentucky try their best to beat us tomorrow. So Dui Cle is a graduate, if you don't know him, of the University of South Carolina and the South Carolina School of Law. He was a staff attorney with the Charleston County Public Defender's Office from '97 to '99. Then he went into private practice and started his own law firm, the Carroll Law Firm, in 2010. He's successfully completed the NPAS breath test course on the Datamaster DMT and the BAC Datamaster, which is the only breath test device approved for use in South Carolina. And he's also completed the NHTSA's Standardized Field Sobriety Test Practitioners course, as well as the NHTSA's DRE Overview course. Mr. Carroll is the President Emeritus of the DUI Defense Lawyers Association. He's past president of the South Carolina Association of Criminal Defense Lawyers, chair of the Criminal Law Council of the South Carolina Bar Association, a member of the National College for DUI Defense, National Association of Criminal Defense Lawyers, and of course, he is a well-known and esteemed member of not only the South Carolina Bar Association, but our great Charleston County Bar Association. And we are really lucky to have Mr. Carroll give us some knowledge here. I will say that when I was either in law school or recently graduated, I attended one of Mr. Carroll's lectures when City of Rock Hill versus Krzyzewski was an issue and came out. And I remember writing a memo as a law clerk or maybe a recent law school graduate when I was working as a clerk for Peter Shade about that case. And we had a successful outcome because of the memo that I wrote. So Mr. Carroll has been making me look like a really, really smart person immediately after I graduated from law school. So I always appreciate that. So I'm going to turn it over to you, Mr. Carroll, for your presentation. And I will just let everybody know that you can enter questions in the chat Q&A section below, and I'll see those questions and I'll ask those questions to Mr. Carroll should we have time, and he accepts the questions after the presentation. So Drew, I'll send it over to you. And again, thanks for taking your time to participate today.
Thank you, Judge Ferguson. Can you hear me?
Yes.
Okay. I really appreciate the invitation to participate in this introduction to the new DUI court. I think it is a brilliant idea to have a separate docket for DUIs. It is sort of a unique an offense with a lot of issues associated, due in no small part to my mentor, Reese Joy. In addition to being a very zealous advocate and a tremendous trial lawyer, Reese found it necessary to involve himself in every piece of legislation that was ever introduced related to DUI. And so a lot of the things that we look at in DUI cases that can lead to a resolution did not just happen. They were, in many instances, long-suffering pursuits. For example, video recording restarted back in the mid-90s with legislators introducing a bill to mandate video recording in DUI cases. That was a process that culminated in 1998 with Governor, I think, Sanford signing that built into law. And I think it's been a very effective tool for both the prosecution and the defense. As Reese would say, it is an honest, accurate representation of exactly what happened. No friend to reward, no enemy to punish. It is what it is. And so among many things that Reese contributed to DUI law, that was one of them. And I learned a great deal from him. Earlier today, I recorded the introduction to a CLE that the South Carolina Criminal Defense Lawyers puts on every year in November. This year will be the 13th annual Reese Joy Memorial DUI Defense Seminar. And I reflected back on Reese's motto. He was an Eagle Scout, was be prepared. And he spent more time and effort, spared no expense in training any member of his staff, CLEs on every issue that even touched the world of DUI. He participated in those. He attended those. And he was indeed, as Judge Maloney knows, a very prepared lawyer when he came into a courtroom on any issue. But DUI definitely was the thing that he gained the most pleasure in defending. He was an engineer by trade and really liked getting into the technology of breath testing machines and other things that are used in DUI prosecutions. So it's my pleasure to be with you. The seminar that SCACTL is putting on for its membership, I put it together and have been doing so for about 17 years. But this year's program is DUI 101. I believe that no matter how many years you've been practicing and what kind of success you've had, that it is always beneficial to go back to the basics and look at those puzzle pieces at the foundation of this area of the law and refresh yourself. Law enforcement officers are required to go through refresher courses on field testing and breath testing and the other things that they do in the course of their work. So I think that it's wise that lawyers also go back and look at the basic fundamentals of this area of practice. And so my presentation today is going to be along those lines. DUI 101, my intent is to cover those basic things that come up in the garden variety DUI cases and the law that applies and the kinds of issues that will arise that we'll have to address. So I think the logical starting point is to go take a look, take a look at the elements of the offense. What does the statute lay out as the conduct that is problematic and would lead to an arrest and potentially a conviction? And so in South Carolina, the state has to prove beyond a reasonable doubt that the driver was driving a motor vehicle, and now moped fits within the definition of a motor vehicle. For many years, a moped was excluded, which that doesn't make a whole lot of sense, because normally if you see somebody on the road on a moped, it's not by choice that they're on a moped on a road where everybody's blazing past them. But it's a motor vehicle, and the statute itself defines motor vehicles. It's got to be within the state of South Carolina while under the influence of alcohol or any other drug or a combination of alcohol or drugs, to the extent of the person's faculties to drive a motor vehicle or materially and appreciably impaired. So we're going to take a look at each of these in sequence. There is often discussion in the early stages of DUI cases, particularly when a defense lawyer reaches out to a police officer. Many of us will make contact with police officers, and I have found that it can be beneficial before tracking Kevin down or before Kevin got this docket, Greg or Will or whomever was involved in the case or you thought was going to be involved in the case. Before going to them, it can be beneficial to talk to the officer and sort of get a feel for where they stand and what their view of the case is. I found that officers that have come in from other jurisdictions where they've been in law enforcement in other states don't appreciate the fact that in South Carolina, it's not sufficient to prove that somebody could have driven a car or could in the future drive a car in order to meet this element of proof in a DUI case. But according to our Supreme Court in State v. Graves, they've got to prove they were driving the car at the time that they were impaired. And this comes up in one vehicle accidents. This comes up in cases where somebody might leave a parking lot of a restaurant or a bar and decide they shouldn't be driving. They pull off and call somebody to come get them or call an Uber. And they're sitting in their car, engine running. Somebody may have had cause to call and say, this is suspicious, which is what happened in Graves. And an officer shows up to investigate. In some jurisdictions, in fact, many jurisdictions, that would be sufficient to prove driving. Having the ability to operate the vehicle would be enough. But in South Carolina, the law is black and white on this issue, and you've got to prove beyond all reasonable doubt that the vehicle was in motion in order to satisfy the element of driving. Now, obviously, proof can come in the form of direct or circumstantial evidence, and we'll talk about that more in a moment. Now, the criminal defense bar, like every other association in the legal business, has a listserv where people will come on with questions about certain specific aspects of a case. And one of those that pops up at least once a year, maybe 2 times a year, is, my client was driving in his field when he ran in the ditch and called a tow truck, and the tow truck driver called the highway patrol, and they came out and arrested him for DUI in a field or some other place. In South Carolina, the DUI law reaches to all property, public or private. Within the state means within the boundaries of the state of South Carolina. So it's not a defense in a DUI case to say that we're not on a public roadway or in a public space. It comes up sometimes when you're in a private parking lot and law enforcement gets involved and we ultimately make arrest. I've had lawyers call me and ask me questions along these lines. So I thought it important to point out that in this state, you can be successfully prosecuted for DUI even though you were not driving a car in a public space. This is a jury charge on what under the influence means. And every trial I've ever had, judges have done a good job of letting the jury know that the offense does not turn on whether somebody's consumed alcohol or even ingested drugs and then driven a car. The offense turns on whether they consumed enough alcohol to render them materially and appreciably impaired before driving a car. And the same with regard to drug impairment. So in this state, and you see on video sometimes that some young officers might believe that, if the person admits to having consumed alcohol and then drove a car, or if they have other objective reasons to believe that somebody consumed alcohol and drove a car, you can tell in their dialogue that they think the standard is you drunk alcohol, then you drove, ergo you're driving under the influence. And while in a very simplistic sense that is true, in a legal sense, with regard to this law, that's not sufficient. The offense turns on impairment, not on the fact of consumption. So the mere proof that a defendant drank alcohol is not sufficient. This is one of those things that I've talked to officers when I talk about getting in contact with them early on to discuss that. I heard you say 6 times on the video that, I got to arrest you because you drank and drove. Do you think that that's the standard? Or, tell me what you believe was evidence of impairment, and you'll flesh it out very quickly whether they focused on impairment or they focused on drinking. Now, it's important to understand the kind of evidence and what evidence is. DUI is unique in that, and we'll get to this in a moment, it's the only offense that I'm aware of where a layperson can give an opinion about a significant issue in the case, and that is whether somebody appears to be impaired or not. Under our law, they can, but there are other aspects of a DUI case where opinion is not going to be permissible or sufficient. You're going to need facts. So it's important to every now and again go back to the definition of evidence and parse out what about this is evidence, what about this is conjecture, what about this is permissible opinion, and whether this witness can provide that sufficiently. The garden variety cases tend to be the ones that you have direct evidence in. The officer's driving down the road, they see a vehicle driving erratically, they make a traffic stop based on articulable suspicion of some crime or traffic violation, and then they make contact with the driver. They employ their senses, their training, their knowledge, their experience, the investigative tools they're trained to use, like field sobriety exercises, breath test, blood test, sometimes urine test, but up to the point of the end of the investigation at the roadside, they've reached the conclusion that they've got probable cause to make an arrest. That's the direct evidence that we see in most DUI cases. But in those one-car accident cases, and in those cases where somebody stopped driving or there's a caller and a bolo, then the question is going to become, does the state have sufficient either a combination of direct and circumstantial evidence or sufficient circumstantial evidence to meet their burden of proof? And based on our law, that is sort of tricky. And I should have included the jury charge for circumstantial evidence to show that it's not merely sufficient to raise a suspicion that the crime may have been committed, but you've got to string the facts together that would lead a jury to the point of being able to decide beyond a reasonable doubt that the conclusion you're suggesting as a prosecutor is supported by that string of facts, and not just suggesting it was possible or that it could have happened that way, but here's why beyond a reasonable doubt it did happen that way. And then, of course, you want to make sure that you limit the presentation of evidence to that which is relevant, because sometimes in roadside conversations, there can be some departures from the primary basis for the investigation. And that may bring a whole lot of irrelevant stuff that could be prejudicial, could be meaningless, just surplusage, but you want to make sure that you parse the case down to just that evidence that is relevant to the question of whether somebody is guilty of the offense of driving under the influence. Now, with regard to the use of circumstantial evidence, the proof of the corpus delicti does not have to come in the form of direct evidence. It may be established by circumstantial evidence when it's the best evidence obtainable. And I think that is a very important issue in many of the kinds of cases where circumstantial evidence comes up. Is it the best available evidence? So clearly, if there is an accident or there is a bolo, the officer will not, in the case of an accident, have witnessed the collision and will be relying on information provided by other parties, whether involved or not, to make his decision or her decision about making an arrest. So that person now becomes a presenter, a possessor of direct evidence of the collision. And so, in my view, unlike a situation where it's a one-car accident and you can draw certain conclusions based on where the vehicle is, how you found out where the vehicle is, other factors like the driver being present, there being other facts to show that this was freshly committed. Unlike that scenario where circumstantial evidence is likely all you can produce, this is one where there is direct proof available. And that is what I believe the law requires, is that you produce that kind of proof. Because of course, the defendant is entitled to confront witnesses that have provided critical evidence against them. And so I don't think that it's possible for the state to sidestep when there is knowledge of somebody who possesses direct evidence and just rely on circumstantial evidence in a given scenario. And I've defended the case where the young lady leaves the oyster roast thinking she's fine to drive, and then pulls out, and within less than the length of a city block decides that she should not be driving, pulls off and parks and calls for somebody to come pick her up. And then we cannot resolve the case by agreement. And so the case ends up at trial. And in that case, and it clearly wasn't in this court, but in that case, the state attempted to rely on circumstantial proof, though there had been a caller and that caller gave great detail. When the state showed up for whatever reason, they did not have that witness. And the presiding judge in that instance agreed that you had the capacity to provide direct proof of driving, and for whatever reason you elected not, and did not allow the state to proceed with the prosecution. But that does come up, and we have many discussions about Graves and about Osborne and what must be proven. Now, when officers go through training at the Criminal Justice Academy in DUI detection, and then in advanced DUI detection at the Criminal Justice Academy, this is a big part of their initial training. NHTSA has pretty much researched and documented all that there is to research and document, and they've identified 24 things that could happen while somebody's driving a car. Officers are taught to look for those 24 indicators as a sign that somebody might be impaired. Obviously, there could be multiple reasons for a particular, somebody speeding up, slowing down. They're lost, they're looking for someplace, but that's one of those indicators. So the DUI case begins when the officer is completing this part of his training. They're watching somebody drive. A defense practitioner, a prosecutor can educate themselves on exactly what the officer's looking for and what they've been told as is the basis for looking for that particular kind of conduct. It's in the participant field sobriety manual. There's a separate publication on these 24 factors that NHTSA has put out. That if you're going to defend DUI cases, I strongly urge you to make yourself very familiar with that part of the training and the rationale for looking for the things that they are looking for. Evidence of impairment. As a part of this training and as a part of the proper assessment of a DUI case, in my opinion, we've got to be able to answer questions about each of these issues here. How is the state going to prove driving? Is this going to be a circumstantial evidence case? Is there a legal issue because they can't produce a witness? Were there no witnesses? But you're going to find in the standard incident report that the officer will explain what led to, in a few words, what led to the initial contact with the driver. So in South Carolina, as we all know, the law mandates that all DUI investigations be video recorded by that investigating officer. Now, there are some camera systems that some agencies use that are passively recording while the officer's driving around town. the system is designed and required legally to be activated no later than the moment blue lights are activated. That's what the statute requires. In those jurisdictions where they have these passive recording devices, you can, unlike in other places, get a minute, 2 minutes of video before the blue lights come on. And that can really tell the story about, you know, the veracity of the allegation that somebody, you know, crossed the center line. Or it can nail down the fact where a defendant says, even believe it or not, to their defense lawyer, no, I never crossed the center line. The video addresses that issue. Not all camera systems are set up that way. And some really do video just from the point that the blue lights are activated forward, although the officer does have the ability to override that default setting and activate the camera when they wish. And you'll sometimes hear and read officers describing that they didn't know if the person was lost or if the person was impaired or what exactly was going on, but they turned their camera on, followed them a short distance to get some more information or to get better proof of driving problems and follow them. Absent those, the basis for the stop, whether the driving is indeed as described by the officer or not, fits into the swearing contest category, where a defendant has the ability to take the witness stand if they choose and dispute the allegation or not. And then otherwise the officer gives his explanation or her explanation as to what the driving violation was. So driving is going to be a part of this impairment analysis. Likewise, when what you have on video does not suggest impairment, somebody's driving down the road, they look fine within their lane, they react timely and appropriately to blue lights, they pull safely off the roadway. The NHTSA standard that sets up problematic conduct that an officer should take notice to, the absence of that raises the question on the opposite end of that spectrum, and that is this proof that the person is not impaired because their conduct is exactly contrary to what NHTSA says are problematic driving maneuvers. And here's an area, admissions. The United States Supreme Court has said Miranda does not apply to the conversation between an officer and a driver after a routine traffic stop. So that conversation is not problematic. But there are instances where it gets well beyond the context of a traffic stop. The officer stops somebody for speeding, smells the odor of alcohol, and then pursues a whole line of questioning along that route. There's probably things that are absolutely permissible and would be admissible in court. And then there are things that I see in some cases that are not, because it is an interrogation and it's after the officer has exerted some form of police power to take control over the citizen's ability to move. Give me your driver's license, step out of the car, go stand right there. Here's where it starts getting into a gray area that could lead to a motion to suppress any statements made because they fall so clearly outside the scope of a routine traffic stop. And so there's also the question of voluntariness that you look at in looking at those kinds of things. In accident investigation cases, things can get way off track sometimes. So that's an area that I analyze thoroughly when assessing statements. You know, everybody had 2 beers. Some people say more than that. Some people say a whole lot. But you've really got to look at, as a defense lawyer, how that information was acquired, what prompted that information. We are a state that our video law is very closely tied to Miranda. And I'll tell you that initially was not a request of the defense bar. We simply wanted after working with Reese, which I did for the last 8.5 years of his life, I got intimately involved in this legislative process and have drafted amendments for legislators and even bills. But our desire was to simply have an admonishment given to somebody in being investigated for DUI, to inform them that they're being investigated for DUI and that they did not have to do field test or whatever. I forget the exact wording of the admonishment that we wanted to be used during an initial encounter. But folks in the Senate on the Judiciary Committee at that time felt like everybody's so familiar with Miranda that Miranda covers all sins. And so our officers have been trained for years about the necessity of reciting Miranda or reading Miranda during a DUI case, particularly before somebody's arrested. But the timing of Miranda has moved around a couple of times over the years, but it's definitely an issue that will come up when questioning goes down a road other than what's logical based on the reason for the traffic stop. And I see the officers who are well-trained, they do protect their case before they begin to interrogate by reading Miranda rights to them, and that really shores things up for them on issues like those where other officers just wait to the very end, and after they've gotten all that information, then read Miranda. A critical part of most DUI investigations is the administration of field sobriety test. Everybody should understand that these are standardized tests. They were developed by the National Highway Transportation Safety Administration when they looked at a broad variety of tests that were being used across the country in DUI investigations. Some of them completely absurd, like pick up a coin off the ground. They decided that in order to improve the quality of cases, they would commission a study on those tests to determine which test of that plethora of tests might be effective tools, period, in detecting impairment. And so they hired a research institution called Southern California Research Institute to study tests, and they narrowed down this 3-test battery that is used today as effective tools in investigating DUI cases, investigating impairment. But they include in the training materials what is called a validation statement. And that validation statement says that these are standardized. So Officer Jones can't decide this is how I do the HDN. I do it in an arc. Can't do that. NHTSA says this is how you do it. They tell you where to hold the stimulus, how high to position the stimulus relative to the subject's eyes, and then they tell you how many times to move the stimulus, how quickly to move the stimulus, how long to hold the stimulus to properly conduct the horizontal gaze nystagmus test. So it's not something that you can adapt. The criteria in Columbia, South Carolina is the same criteria in Columbia, Missouri. Criteria in Miami, Florida, same as in Miami, Ohio. These are standardized, and the manual gives you everything you need to know about the procedure that is required, the clues that NHTSA developed as indicia of impairment, the proper grading criteria, and then it concludes by saying these standardized protocols must be followed, or you've invalidated them for the purpose for which they were designed and intended to be used, arriving at an opinion about impairment. And that's NHTSA's. That's not anything that Reese Joy was able to get written into a book, and certainly not Drew Carroll, but that's what NHTSA said. The only case that I'm aware of significance that addresses this is an Ohio case that talks about the necessity of administering the test, interpreting the test in exactly that standardized way. And in that Homan case, that Supreme Court in Ohio said that if you invalidate them, then you can't rely on them and use that as evidence of impairment. And so that's an issue that when I assess field sobriety test administration, I have a couple of different motions depending upon what I see based on the standardized requirement. Now, the only case that addresses a field sobriety test in South Carolina is State v. Sullivan. And that's a case where Reese defended someone and among other things, an HGM was administered and he moved to exclude it. And the court found that the HGN, just like the one leg stand or the walk and turn exercises, is a valid field test, but that it must be administered in what they said is that it can be used to present objective evidence of impairment when used with other field tests. So there will come cases where that's the only thing that the officer did, and under Sullivan that may not be sufficient. And then you'll see instances where there's a voluntariness question about field test. And this will come up where somebody will indicate they're not going to do the test, and then the officer exerts some coercion, some influence over somebody's decision to take it or not take it. And that can be something as slight as, I'm gonna have to go on what I've already seen if you don't take the field test, which I think is probably an appropriate statement, to if you don't take the test, I'm gonna arrest you and take you to jail. And I think that probably gets out of bounds because most people at that point are gonna do the test, period. Now, the test identify in the NHTSA research that not everybody's a suitable candidate to perform the test. And some officers do a thorough job of determining whether the person's a good candidate or not, and some don't. In fact, many don't. For example, somebody who's more than 50 pounds overweight, NHTSA has said is not a good candidate for a one-leg stand, and had previously said not a good candidate for a walk and turn exercise. Somebody over the age of 65, not a good candidate according to NHTSA for a one-leg stand, and previously said the same about the walk and turn exercise. So there are factors that need to be assessed along those lines in a DUI case. As I mentioned earlier, in every instance, the officer is going to express what observations: bloodshot eyes, unsteady on their feet, dazed and confused, strong odor of alcohol. That's their observations. I think they're entitled to give those. They can give an opinion about impairment, as can anybody else. According to the Ramey case and a few others, it is acceptable based on an assumption that most people have seen somebody impaired from alcohol, and as I'm being prompted with a question. They know what impairment looks like, they know what impairment sounds like, and so the law permits them to get on the witness stand and offer their opinion about impairment. And like I said earlier, I'm not aware of any other instance in a criminal setting where somebody can offer a lay opinion about an issue that is a critical issue in the case. But there's no question here that can be done. I got a question asking me if I was observing, and that's gone away, but now it's not allowing me to move my screen. Okay.
Got it fixed? Okay.
Got it. Yeah. All right. Now, blood alcohol concentration evidence. It's obtained either in most DUI cases under the implied consent law. We all know that if you drive within the borders of South Carolina, by the act of driving, it is implied that you will give a sample of your breath, in some instances your blood, some instances your urine, if you are arrested for driving under the influence. But because what the implied consent law really is targeting, and that is the production of evidence to be used in a criminal prosecution, then you've got to be able as a citizen to withdraw that consent. And so before asking anyone, and an officer who arrests somebody in a garden variety DUI setting, traffic offense, one car accident perhaps, is mandated by law to take the person they've arrested to a certified breath test site and offer them the opportunity to provide a breath test. In order for that offering to be valid, there's certain rights that must be conveyed to that person, both in writing and verbally. Those rights are called implied consent rights. And so an officer is required to read them, give a written copy to the arrestee, so that before they're asked to make a decision about giving a breath sample, they understand that they've got the absolute right to refuse to provide a breath sample. But because driving is deemed to be a privilege and not a right, the government who created the privilege to drive has the ability to regulate it. And so they can impose a consequence on someone who chooses not to give a breath test for whatever reason. And that consequence in a first offense case is an automatic suspension of the driver's license for a period of at least 6 months. And the word "at least" is in there to cover scenarios where somebody has a history of an implied consent violation or a DUI conviction. That person's suspension period is going to be increased above 6 months, depending upon how many times they've been in the situation. So a second time appearance, somebody batting around for the second time, is going to be looking at a 9-month rather than 6-month suspension if they refuse a breath test after having something on their record, either implied consent violation or DUI or DUAC conviction. The person's told that they can provide a breath sample if they choose, and that the machine is going to analyze the breath sample and report a blood alcohol concentration level. And if that level is 0.08 or more, rather than being charged with driving under the influence, they could be charged with the offense of driving with an unlawful alcohol concentration. If they provide a sample and the result is 0.15 or greater, their license will be administratively suspended immediately, just as in the case of a refusal, and that period will be for at least 1 month. So this statute's, as I said, not anything at all to do with public safety. It is to do with evidence gathering, because you can be drunk to the level of being comatose and you're only going to lose your license for 30 days. You refuse because your brother-in-law is a DUI lawyer or a deputy sheriff, and you're going to be suspended for at least 6 months. And so there's law in other jurisdictions that addresses the question of what happens if the officer, rather than reading it or after reading it, sort of ad libs and then comes back and explains it and gets things wrong. There's good law in Georgia that talks about having to stay within the 4 corners of the document. Anytime I've had that issue come up, it's been pretty clear that the information provided was so erroneous that they could not have made an informed decision on giving a sample or not. Now, the presumption at this point, or the suspension, is presumptive. Every presumption weighs in favor of the state. And so that driver, if they refuse or they blow a 0.15 or more, they leave the detention center with no driver's license. Technically, if they're an out-of-state driver, they would leave with their driver's license, but they would be given, in both cases of an in-state and out-of-state driver, a notice of suspension document telling them you can't drive in the state of South Carolina until a license has been issued to you. Officers don't tell them during the breath testing process that they will be able, even if they refuse or blow 0.15 or more, to get what is called a temporary alcohol license and have an administrative hearing to challenge the presumptive suspension. They leave that part out. They're not required to do that. SLED doesn't train them to do that. That comes up after the test process ends. But many people walk out of jail with no driver's license because of the implied consent law. And Kevin mentioned during his comments, he doesn't get involved in that. There's only a couple of prosecutors that do actively get involved in that. And frankly, it is for purposes of using it as a negotiation tool. And it can be an effective tool to reach a fair resolution in a given case, because when somebody waives the challenge to the administrative suspension, they're accepting that 6-month suspension, which triggers a requirement. They enroll in and complete the ADSAP program, and it leaves them with the option during that time of obtaining a route restricted driver's license or an ignition interlock driver's license. Somebody who has never had a route restricted license is eligible for a route restricted license. Somebody who has used a route restricted license for one of the few reasons that you could use one would now only have the option of getting an ignition interlock driver's license installed in their vehicle. So that does bring consequences to the table to get someone's attention. And in cases, you can resolve a case where they plead guilty to reckless driving in court and waive the implied consent hearing. Some officers are open to that when you talk to them. Some don't care one way or the other. There's at least one officer that I know of in the city who this is more important to him than any other aspect of the case. So that's there as a tool. It's litigated, and because it is under the umbrella of an administrative agency, it is at the lowest rung on the ladder of priority courts in South Carolina. And so these things get continued a lot because like there's a docket in the city on Monday. Implied consent hearings they take place on Mondays and Tuesdays. Those cases by rule, and there's a case. There was an instance where a lawyer asked for continuance and the administrative court went forward with the hearing and ruled against him, and his client's suspension was upheld. He appealed, and I think Justice Few ultimately authored the opinion, but it basically sets out what we all know to be the rule, that you've got to give way when there's a conflict to the higher court. So they do last a while, and that's why they can be effective tools in negotiating, is because they're still out there with real weight in each instance. And I guess you could decide to get an interlock driver's license, even though you've still got the option for a route restricted license, just to, put something else on the table in a negotiation. SLED has a policy. Breath testing in South Carolina, according to the legislature in our implied consent law, relegates the responsibilities for developing policy and overseeing the breath testing program to SLED. And so SLED policy 8.12.5 sets out step by step how a breath test should be conducted in South Carolina. The statute, as we know, provides inference levels for blood alcohol concentration levels that are obtained pursuant to the implied consent law. Interestingly enough, some officers, either because of, and they usually arise in accidents because the breath sample is not the only testing medium that could be relevant in a case. If an officer believes while somebody's in a breath testing room that they're under the influence of a drug other than alcohol, then the law gives them the discretion to take the person to a medical facility and request a urine sample, not a blood sample. Blood is limited to instances where the person is transported to a hospital and a licensed medical professional says, I can't allow you to take the person to a breath test site, because remember, the law mandates that they take anybody they arrest to a breath test site. The language is first must be taken to a breath test site. So when the person's been transported to a hospital, that doesn't necessarily mean that it's a shift to blood. It can only shift to blood if the individual is unconscious or a licensed medical professional says, I can't allow you to remove them for some reason acceptable to the licensed medical professional. And then the officer can approach the individual, read the same advisement, give them the same advisement, and then ask if they will provide a blood sample for blood alcohol concentration level testing. Now, there are time limits. In the statute, a breath test must be collected within 2 hours of arrest. A blood sample must be collected within 3 hours of arrest. There is an unpublished opinion from the Court of Appeals that upheld an implied consent ruling that ruled in favor of a driver in restoring their driving privilege when the breath test was administered outside the 2-hour window. And so they found that there's the likelihood, the hearing officer in that instance found that that was unfair given the requirements of the statute, and given it was so far away from the incident time that it was not going to produce accurate evidence of impairment. And so the state appealed after the ruling in the administrative law court to the Court of Appeals, and the Court of Appeals upheld that in an unpublished opinion. Now, that's all under implied consent, and you get those inferences. In many accident cases, particularly serious accident cases, even though under the felony DUI statute, there's a separate statute that authorizes an officer with probable cause to do whatever they need to do, basically to get a blood sample from somebody they believe to have committed felony driving under the influence. That statute is vulnerable based on United States Supreme Court law in Missouri versus McNeely. So I've seen a trend, and it's over several agencies and it's all over the state. Certainly the Highway Patrol is doing this now, I think, as a matter of course, where rather than try and rely on the 56.5/2946, it allows them to get the blood based on a felony DUI, probable cause of a felony DUI. They're using search warrants to get blood. And there's certainly an argument that blood values under search warrants are not under the implied consent law, and therefore don't fit the same parameters with regard to inference levels. There's no law that the inference levels are tied specifically to the implied consent law, not to evidence obtained pursuant to a search warrant. So that's what I'm seeing a lot of is search warrants used to get blood. Some of them good, some of them a clear fishing expedition, but we assess each for what it is. Now, there's been a very marked uptick in the number of DUI drug cases across the country, and where opinion is clearly permitted under the issue of alcohol-induced impairment. When we get into the world of drugs, we're into something that is indeed very scientific, and an officer would need to be able to rule out medical problems as contributing to or causing whatever indicia they're interpreting as indicia of impairment. So, you know, I don't know what the current count is of the number of states that have legalized marijuana for medical or recreational use, but it's definitely a growing number. And in places like Colorado, I know a number of lawyers that practice DUI defense there. They are seeing a lot more DUI drug cases and DUI drug prosecutions than ever. And there's always been some basic flow here, usually based on prescription medication ingestion. And I'll tell you the one client that walks in that seems the most dumbfounded by why they got arrested for DUI is the client who was taking medication their doctor had prescribed for them. And clearly our statute makes it a crime to drive when you are impaired as a result of drug ingestion, and that drug could be a prescription drug, an over-the-counter drug, an illicit drug, just any drug. Under the implied consent law, if an officer, as I said earlier, suspects that they're under the influence of some substance other than alcohol, some drug other than alcohol, then they're entitled to get a urine sample. And frankly, a urine sample is relatively useless for forensic purposes. And I've talked to the director of the SLED lab, and they wish that they'd remove urine from the statute. There was an effort about 5-6 years ago to add saliva testing to this, where they take a swab and take somebody's saliva and put it in a tube and send it off to Minnesota to get it tested. I happen to testify in a Senate subcommittee hearing against that, along with the director of the SLED lab and the attorney general, not wanting anything to do with that. But frankly, urine fits in that same category. Now, when we get to drugs, what you're going to get in most instances is a report that THC was present or benzodiazepines were present, and there's not going to be a quantification. And by its very nature, it's proving what was not in the bloodstream at the time of the incident. It's a urine sample where the body's metabolized the drug and discarded the drug, and it's in waste. So unlike a blood sample, which is going to tell you in real time what's coursing in someone's veins over their brain and influencing them physically and cognitively, a urine sample is not going to give you that evidence. But the law allows an officer to inquire about it, ask for it, and get it in cases where citizens decide to give that under the implied consent law. The other area where drug impairment evidence comes up is there is now this designation. Officers go through training to become what is called a drug recognition expert. And they're trained to conduct an evaluation that involves some field tests and some pulse taking and looking at the size of pupils and things of that nature. There's a 12-step program to include asking for a urine sample at the end that is being used. And this was slow in coming to South Carolina, but I think about every agency has DRE officers now. But again, where something is broad, widespread and common to encounter as alcohol, and you smell it on their breath and you see them drinking and you know why they're impaired, there's no way under the sun that anybody outside a trained professional in pharmacology, pharmacokinetics, toxicology, it's going to take legitimate expert opinion to offer competent evidence of drug-induced impairment. And there have been challenges in courts all across the country to this classification as expert. And there are many courts that have said you can talk about the evaluation, but you can't be referred to as an expert. And there are courts that are saying you've got to apply the same analysis as you do with any other expert opinion evidence. And that, in my view, falls outside the capacity of the average traffic officer anywhere in the country. So, we've got the requirement under Rule 702 of the South Carolina Rules of Evidence. And then there's a case where they offered the opinion of somebody who was not an expert in the subject matter and reversed, in this case, of the matter and care of the treatment of Thomas S. But I think it's something that is going to be, it's not been litigated in South Carolina to my knowledge, and I think I'm pretty attuned, but I think it will be litigated. And so any defense lawyer, any prosecutor, I think you've got to approach this as evidence is outside that alcohol umbrella. This is something that's far more involved, where by their own admission, the developers of the program claim that they are able to train these officers to assess and eliminate medical explanations for whatever manifestation they could see. And so that doesn't make sense to me, but we'll at some point get the opportunity to litigate the question. But that is the kind of evidence that I am seeing become much more prolific around the country. Now, the issue that makes and breaks a lot of DUI cases. This is the only law of its kind in the country where there is a remedy written into the statute to direct the outcome when the statute's not complied with. And we've got ample case law. The initial case, Judge Ferguson referenced earlier, is Raquel Wieserczynski. Since then, probably the case that's most cited is Town of Mount Pleasant versus Roberts. And the Supreme Court went to considerable lengths, I think, to emphasize the point that this law must be complied with as written, and dismissal is a remedy unless the state is able to meet one of the statutory exceptions in subsection B of that statute. And so it's very straightforward. And this is the first analysis I do in every DUI case. The most important piece of evidence, period, in my view, is the video recordings. And so I go through and look to see compliance issues to begin with, and then I assess administration and field tests to see if they're done in conformity with the standardized protocols dictated by NHTSA. And then I look at other things, but it is, I think, a very valuable law enforcement tool. When it's complied with, then the state knows they've got a very good DUI case, and there ends up being a lot of pleas to DUAC. When it's not complied with, then the defense makes a calculated decision on whether a reckless is sufficient to pack your bags and go home, or you want to try and get it dismissed outright. And I guess there are a whole host of factors that would decide which makes the most sense. But this law is, there's an attempt every couple of years in the legislature to undo it, but I don't see that happening. In fact, I think the trend is going the other direction, where there's going to be a lot more law with regard to video recording because of some of the things that we've seen in our, tragically in our recent past, were things that could have been, completely ignored or big deals now because of video recording. So I don't see it going anywhere anytime soon. And I think it's a good feature of the law. And when I've got a bad case, I bring my clients in, I show them the video, I ask them to explain to me, what about their driving? What about their statements? What about their test performance, et cetera? Likewise, regardless of what a prosecutor may think about a case, if I look at it in the video, the guy blew a 15, but he looks good on video, he does well on the field test, so on. I'm going to tell that guy that I think that's compelling evidence, because I do. I believe that is compelling evidence, and I think juries look and trust what they can see, even over what a machine says they should be seeing. And again, this is mandatory, and I believe that is my final. Well, I guess I cited Roberts here in this slide. It's got to be, the state must produce direct evidence of a DUI. Remedy is dismissal. So that is my presentation. So.
All right, Mr. Carol, we appreciate that. Thank you so much. I think I got 2 text messages from participants and attendees that what you're saying is extremely informative and very helpful. On behalf of the Charleston County Bar, the City of Charleston, and everybody who can't clap virtually, I just want to thank you so much for taking the time to do that. I don't see any questions in the chat, so I'll just move on to the next section. But we are so appreciative of your time and your ability to share your sharing your knowledge with us. I'm going to quickly go over, and I'm going to share my screen. Let's see if I can do this right here. Share, and I'm sharing this screen here. Great. What you should see is my PowerPoint presentation here. It says Introduction to the DUI Court. And I'm going to quickly go over just a few things because I know we're short on time. First, I kind of want to start with a word of comfort here. It's not lost on me that you all have been working efficiently in the municipal court for a long time, okay? And your practice in the municipal court, for some of you, it's your bread and butter. It's what you do. You've made yourself a very well-known name, and you're good at it. And you don't want another thing to have to worry about. And for others, you know, your practice in the municipal court is a great baseline to frankly, keep the lights on and keep your office running. And it gives you the freedom to explore other areas of the law and expand your practice. And again, you don't need another thing to kind of get in your way. So what I want to start out in saying is that we're not trying to reinvent the wheel here, but we are trying to put some more tread on the tire. So the purpose of the DUI court, you can see there, is just to efficiently move some of the cases that are stalled and to give you a service to very, again, efficiently take care of your client in a fair and speedy way. I do think that a DUI charge, DUI arrest is one of the most serious offenses in the municipal court. And it has consequences if it lingers around. You know, people need to get jobs. People need to apply for school. People need to get scholarships. And just having that pending DUI, you know, does not serve them well. So we want to try to move these cases as quickly as possible. I'm going to skip the slides about the numbers and just go over, I think, 2 or 3 main points. First, you can see that we have 12 terms of DUI court for 2021. And I was excited about sharing the screen with you until this came out from the Supreme Court. Judge Morrison actually alerted it to me this morning. As you can see, Justice Beatty and I believe Judge Rico Flores mentioned that jury trials won't be able to commence after December 4th, 2020. So our our terms of court are essentially changing from trial terms to pretrial terms. 2 quick things I want to discuss with you, and these are really important, and it's a really big benefit that we've got here, is that we can use technology to move these cases. We can have hearings and pleas by way of Zoom and by way of telephone. Pleas can happen and occur, as you know, by way of affidavit. And if you look, the South Carolina Supreme Court in its forms, Form 656, I'm going to click on it. Actually, I think I've got it pulled up, is a form affidavit. Oh, excuse me. Just 1 second here. Is this form affidavit. And I want to alert you to two things, and this is really important. If you use this form affidavit, which is highly encouraged, it was supplied by the South Carolina Supreme Court and was modified in May of this year. You look at paragraph 9, and I don't know if this is a kind of hint, but I'll read it to you. It says, I understand that I am entering a plea of guilty by this agreement on an emergency basis during the COVID-19 pandemic, and that my ability to enter a guilty plea by affidavit rather than during a court hearing is only available while the order of the Supreme Court authorizing a plea of guilty by affidavit dated May 7th, 2020 remains in effect. Now, it's my understanding that, and it's going to be my practice to continue to accept pleas by way of affidavit as has been done in the past, even beyond the court's May 7th, 2020 order. But what pops up in my mind is given the court's recent interest in the municipal and magistrate courts in other areas, does this mean that the court is going to come down with some decision about taking pleas by affidavit in the future? This is a form that was made by the court and it's specific to the magistrate and municipal courts. So I question why that's there if pleading by affidavit had been done in the past. So I say that to you to give you a heads up. If pleading by affidavit is something that is useful to you, let's start doing it while we can, if you will. Further, let's try to use our technology. I didn't do well trying to switch to that screen, but if the court is comfortable with conducting hearings by way of Zoom and accepting pleas by way of Zoom and telephone, let's use that technology to our advantage. I remember, I don't know if Councilman Seekins is participating in this webinar, but in my conversations with him and other attorneys, they want to see how technology can be used efficiently to service the community and service the city. So let's do our best to take advantage of this because, you know, it's efficient for you, it's efficient for the court, and it can help these cases move. The second thing, and this is a point of personal kind of privilege I want to alert you to, is paragraph 10. What I have seen in some of the pleas that I've taken is that a defendant who has received the benefit of pleading to a lower charge lesser than DUI, you know, careless driving or reckless driving, they also, or the attorney also notes that the sentence will be, and they write in right here, you can see my cursor, the minimum fine. And what gives me pause there is I want you to make sure you're not promising your client that he or she will receive the minimum fine if she pleads by affidavit. That kind of gives me some concern, although I'm happy to hear why a defendant who receives the benefit of a lower charge also needs to receive the benefit of a lower fine. But I don't want any confusion, and I don't want you to be caught between a rock and a hard place in promising or saying that your client, you plead by this affidavit, we're going to write the minimum fine in, and that's what you're going to have to pay. And I always ask the prosecutor if they did in fact recommend that sentence. And if they say, well, I didn't recommend that sentence, but I don't take any position to it, that's not the same thing as a recommendation. So just be careful about that. So those are the two things I wanted to discuss. Again, we're short on time, but I also wanted to alert you that the municipal court, we have drafted guidelines for conducting trials in light of COVID-19. It's been sent to the Supreme Court for review. Of course, we haven't heard back, and because of today's or yesterday's decision or order by the court, I don't know if we'll hear back soon. But when we do, get those guidelines approved, you might want to find a way to take a look at them and get familiar with them when we publish them, because the courtroom is going to look a little bit different. For example, during trial, if you look at that last bullet point there, during trial, the attorney chairs will actually be kind of facing each other in the courtroom. And depending on which side you're sitting on, you'll have to look left to see the judge, and you have to look right. I hope I did that right. And you have to look right into the gallery to see where the jury will be sitting and deliberating. But again, because of the spike in COVID cases, we may need to revisit that. That's all I'm going to go through. The materials you have that Mr. Wolf sent out has our complete slide, but as you will learn about me, I like to be efficient, I like to be on time, and I like to end on time. So with that, I'll see you all Monday morning at 9:30 if you've got a case on next week's docket. Here is my contact information. The best way you can reach me is by email. I am pretty responsive to email. It's also in your materials. Also, I need to send this back out, and I'll send it back out to David Wolf. I did not place the contact information for the prosecutors and the public defender, and they gave me permission to send them that information. Please note Mr. Hale's email. It's charlestonprosecutor@gmail.com if you haven't had any dealings with Mr. Hales. And also, I do want to end with thanking Will Bryant and Judge Byrd for mentioning that your case does not have to go on the DUI docket if you're proactive. So let's be proactive and try to resolve cases on the front end rather than the back end. Because I will say, the DUI court was established to move DUI cases and to try DUI cases. If you know me, I've been a state prosecutor, a federal prosecutor, and I enjoy trials. And I'd like to see cases get resolved by way of trial if need be. And I don't want to get in the way of that. I want to help facilitate that. So I see that we've got one question in the Q&A. Well, it's just a appreciative note. So thank you all. So that's all I've got. Sorry, we're 10 minutes behind, but I appreciate all of your time. I look forward to serving the city and serving you all as the DUI judge. And let's get to work. Let's knock this out and get to work. This Charleston bar is just a family. It really is. I truly believe that. And I think we can accomplish some great things if we work together. So thank you. And David, I'll send it over to you. Appreciate it.
Great, thank you all. I appreciate all the panelists, and you will have a number of other opportunities for CLEs between now and the deadline. And if there's anything that the Charleston County Bar Association can be doing to help, please let us know. Thank you, and I hope everybody has a great weekend.